Tonight, the nation's highest court is divided over whether police should have a warrant before searching cell phones of people who they arrest, even if the cell phones were involved at all in the commission of whatever crime it was. And the justices are looking at two cases. The first, Riley versus California. David Riley pulled over for driving with an expired license. Police searched his car and found guns. Then they went through his phone and they found evidence that got him convicted of attempted murder charges. The second case involves Warrant, who was arrested in Massachusetts for dealing drugs. Cops searched his phone and they found addresses where they discovered more drugs and a gun. Now, under the Fourth Amendment, police require a warrant based on probable cause before they can conduct a search. All right, I'm going to let you have the easy side of this, and I'm going to make poor Jimmy have the counter argument. You're on the high court right now. I'm sure you'd like that. And they say, Chief Justice Douglas, what about it? Should cops, if they're arresting somebody, not pulling over willy-nilly, but if they're arresting somebody for a crime, should they be able in the search to look at someone's phone, yes or no?
No, and I don't even see it as being close. Usually these searches are for the protection of the officer in the grabbable area, things like that. You're talking about a rule that will trump the Fourth Amendment, basically saying for some reason you don't have probable cause to get into the person's phone, but now just because the person's under arrest, you can search through their phone. I don't even see it as close.
Jimmy, I'm going to make you play devil's advocate on this. I know philosophically you're more with Doug and Bill on this, but make the argument. Yes, you are under protest. You're doing this. The argument one justice said was, hey, theoretically, jaywalking could get you to have to turn over your phone and basically self-indict yourself. Why is this a good idea?
Because it's an extension of Supreme Court rulings. In these cases in particular, and in the Supreme Court, they've got two car stops. Getting arrested in your car as opposed to your home is different. And United States versus Belton versus New York, rather, the Supreme Court held, and I quote, "Any container in the passenger compartment may be searched whether it is open or closed, since the justification for the search is that not that the arrestee has no privacy interest in the container, but that the lawful custodial arrest justifies the infringement of any privacy interest the arrestee may have."
Now,
it's like a diary. It's like a diary.
Well, a container, we always thought of it as somebody's got an open container, they're drinking something or whatever else, or is there a gun in the glove box or something. A phone now is part of all of our personal extensions. But if nobody walks around without a phone right now. So if you have a phone on your person, and 90% of the public does, that's fair game.
It is fair game. Under Belton, it is fair game. Your diary, if it's in your pocket,
did a very nice job.
If a drug dealer in his pocket has a diary, and in that diary he's got all of the sales he's made, who he's made them to, and the phone numbers and so on and so forth, that is searchable incident to a lawful arrest. It's not a container, but nobody can dispute that it is searchable.
Well, is the smartphone a container? Because if a smartphone is not a container, then they have no right to search it. You know, basically, if a police officer makes a stop, let's say, on a charge of driving with an expired registration, sees a smartphone in the car. Now, he has no probable cause to believe that that smartphone contains evidence of crime, so he could not get a search warrant. So basically, as Doug pointed out, if the Supreme Court upholds this, then they're throwing the Fourth Amendment out the window. There is no search warrant requirement.
I want to get to one more thing here before we run out of time. And please sound off on that same question online. Everybody, should cops need a warrant to search an arrestee's cell phone? All right, and you see the question, and just go to Twitter and Facebook and stuff. Now, New York State's Chief Justice, he's allowing law students, or he'd like to let them take their bar exam early in exchange for pro bono work. So you can shave a semester off, in effect, and the tuition attached to it, and get more actual real-life work involved, but you're doing it on the arm. Now, the New York Times says a scarcity has arisen of lawyers who actually serve low and middle-income people in civil matters like foreclosures, tenant-landlord disputes, and it goes on to call it a stubborn problem. And Jimmy, we've seen more people, law school applications are at their lowest since 1977. I mean, I remember everybody was going to law school in the early 90s. But is this a good or a bad idea?
I think it's a great idea. I think it's a great idea for many reasons. First of all, we all know that the last semester of any school anybody goes to, nobody does anything. So here you're going to take the last, I mean, how many college kids do we know? It's their last semester and they're just having fun. You're going to take that last semester. You're going to give these kids on-the-job training. They're actually going to be practicing law. They're going to be serving the public. They're going to be doing a public service for nothing. I think it's a great idea. They're going to be absolved of having to pay these astronomical tuitions which have gone through the roof for law school. I can't tell you how many young lawyers I interview for jobs, and I'm stunned at the debt that they have amassed without being able to find a job. I think it's a great idea.
Dougie, let's say there's a cousin you don't like that you don't want to do a favor for it, and he or she's got to go to one of these attorneys. You comfortable that somebody after a couple years of law school is ready to take the case?
Well, I think that if it's important for the courts and important for the state, you have a lot of experienced lawyers out there that are willing to do this, but they can't do it financially. If it's important for the courts and important for the state, well, maybe the state and the court should step in and pay these people. The bottom line is you're sending law students out there that don't have any experience.
Yeah, but Doug, they do it all the time. You've got people who work for legal aid, they're law students, they actually
give you the
go
last
to the
word,
court,
Bill.
and they're supervised.
Well, I'm just asking myself, you know, the law student who's doing the pro bono work, who is his opponent? I mean, what's the quality of the representation he's going to be able to provide his client against an experienced attorney? So, you know, I think in theory it's a great idea, but in practice, I'm not sure that the client's going to be well served.
Good stuff tonight, guys. Got a lot in here, and that is all the time here for the gentleman and myself. We will see you tomorrow evening at 6 p.m. Till then, have a great night.